So thank you so much. It's really a great honor to be here. It's one of these sort of moments that makes me really happy to have gone back to law school. I worked as a philosophy professor for a few years. Sort of realized that there were sort of interesting judicial questions I hadn't properly, I wasn't able to consider in my philosophical work, and I was particularly interested in this intersection of legal rights and public international law. And what I want to do today, and obviously I'm sort of limited, I recognize, to about 25 minutes, is I want to try to provide a brief sketch of the ways in which public international law has been received at the Canadian Supreme Court. And the argument I'm going to try to advance, and recognizing, of course, yesterday I now have a new case to read, is that public international law has largely been used as a mechanism, at least in certain types of charter cases, to restrain or to prevent the protection of the rights of Canadians acting overseas. So if you look back as far as Albert Van Dicey, Dicey wrote in his interesting comment on the conflicts of laws that comedy is used as a view which affords a singular specimen of confusion of thought produced by laxity of language. And it's this question that I want to ask is, how has the Canadian Supreme Court used comedy as a principle of international law when forced to adjudicate the extent of charter rights extraterritorially? So I'm going to focus in particular on a couple of key issues in the scholarship. The paper, in fact, and if you read it, which I'm happy to send out, goes through the various ways in which comedy is used as a matter of public international as opposed to private international law. So the principles of international law, as we all know, are only partially incorporated into the Canadian legal system. Like the United Kingdom, then, Canada is a dualist system. The English common law divides, broadly speaking, international law into customary law, traditionally referred to in English jurisprudence as the law of nations, and then treaty law. Only the former is automatically part of the legal system in the United Kingdom. The Supreme Court has consistently held that the same rules govern the use of customary international law in the Canadian constitutional order. The general rule, then, is that principles of customary international law are binding unless Parliament takes explicit measures to exclude them. And so the power of conducting international relations and treaty making, again, as we know, is vested in the Crown. And although the British North American Act did not contemplate that the Dominion of Canada would enter into treaties, when Canada received competency in foreign affairs under the Statute of Westminster, the power of treaty making became a power of the executive branch. Under those rules, conversely, a treaty will have no effect in Canada absent its incorporation into our domestic legal order. And so this, in fact, has posed a dilemma for courts. And I think what I'm going to try to do is sketch out how that dilemma looks in practice when applied or when dealt with by Canadian courts. The fact that treaties, including most notably international human rights treaties, don't carry force in the Canadian constitutional order means that courts who wish to give effect to international legal norms which have not been legislatively enacted must do so in one of two ways. They can either claim that a treaty norm is also a rule of customary international law and thus applicable, or that the norm itself is derivable and serves as some general interpretive principle of international law. Now, the key problem that comes forth often in Canada is, what are the rules governing extraterritorial jurisdiction? And we see this most notably in Hape and in Cotter, but also in a line of other cases that have emerged from the Canadian Supreme Court in recent years. So what I want to do then is ask, what exactly is comedy as a principle of public international law? And then I want to ask, has the Supreme Court correctly understood it? So with respect to the former, I'll be relatively brief because I recognize I'm not speaking to an audience of public international lawyers. But with respect to the latter, I'm going to conclude that the Canadian Supreme Court has largely misunderstood the nature of comedy as a matter of law. So just in general, comedy in the public international law context is the principle that states shall refrain from questioning the lawfulness of another state's acts and restrict themselves from issuing such judgments and orders when to do so would amount to an unjustifiable interference. As a matter of international relations, comedy has traditionally conditioned many of the actions of sovereigns. As a matter of courtesy, for example, flag salutes to foreign ships on the high seas are performed regularly and are motivated solely by courtesy or tradition and not by legal duty. These actions are based on what the French call courtoisie and exist in the relationship between states, do not reflect obligations of international law broadly. Now, of course, the problem is, anyone who's worked in international law knows, the boundary between comity and positive legal norms is not always clear. The clearest practical distinction, if you wanted to draw a distinction, is that the practices established by comity lack the weight of opinio juris. That is, they don't have the sufficient state backing to establish them as norms of international law. But given the notorious difficulty of establishing opinio juris, this only takes you so far. The general statement, though, and the general belief amongst international lawyers is that the principles of comity should be relied on only to elucidate the meaning and purpose of a rule of international law, rather than to establish the existence of the rule itself. And the reality is, international lawyers do not think very highly of comity. To quote from Akehurst's textbook on the subject, comity, Akehurst writes, is a wonderful word to use when one wants to blur the distinction between private and public international law, or to avoid clarity of thought, and I'll just put in brackets, altogether. Well, where you say, it's sort of plausible, you might say, well, why is this going to particularly matter? Well, it's going to matter in cases where Canadian courts have to give effect to the actions of foreign sovereigns. So comity, as one might imagine, tends to be much more dominant in the private international law context, particularly related to questions of what effect to give to foreign legal acts, marriages, divorce decrees, acts of that sort. But it does tend to emerge in the context of search and seizure and or other types of Section 7 cases in the Charter context. So for reasons of time, I just want to focus in particular on HAPE. Now, for those of you who are not familiar with the fact pattern in HAPE, HAPE is an extraterritorial search and seizure case. So, in HAPE, Canadian businessman is working in the Turks and Caicos, and the RCMP have every reason to believe that this individual is engaged in money laundering. And as a basic factual proposition, he almost certainly was. So the RCMP traveled to the Turks and Caicos, and this is sort of an old story. I suspect most people in the audience know HAPE. The RCMP traveled to the Turks and Caicos and liaised, and I'll use the word liaise because the exact nature of the relationship between the two police forces is unclear, but they liaised with the police in the Turks and Caicos. Though the RCMP wanted to organize a raid on police offices on HAPE's offices in the Turks and Caicos. However, they did not acquire a warrant, nor did they believe that they were required to, and instead they relied on the local detective operating in the Turks and Caicos, the local superintendent, to acquire that warrant if necessary under international law. Now, I say if necessary because it's actually an open question as to whether or not that warrant was ever acquired. And if you read the facts in HAPE, the warrant is never introduced into the record. But assuming that there was a warrant at least putatively issued, the question is what effect should be given to any evidence seized in the raid on Mr. HAPE's offices where that warrant almost certainly didn't comply with the Charter. Now, writing for the majority, Justice LaBelle, found that the actions were not carried out by Canadian authorities under the meaning of Section 32. Now, I think there's an open question here as to whether or not that's true. But LaBelle finds ultimately that the actions don't fall within the scope of Charter protections. He drew then on but going further, he drew on the principles of sovereign equality of states, comity, and territorial jurisdiction to limit the scope of the Charter. So first, LaBelle says, and I think this is quite correct, that international law, as a general rule, requires respect for the sovereign equality of states. Second, he argues that the principle of comity, and here again comity rears its head, and this is a constant line of reasoning throughout these cases, that the principle of comity requires that the laws be interpreted in a manner compatible with the sovereignty of other states. And finally, he found that as a principle of statutory interpretation, legislation will be presumed to conform with international law. So, international law requires respect for the sovereignty of states. Comity between states is required as a principle of respect for respect for sovereignty. And third, as a principle of statutory interpretation, legislation will be presumed to conform to international law. So, if you start with those three presumptions, and it's a second one I wish to challenge, then it's natural that the majority would find, as it did, that jurisdiction cannot be exercised by a state outside its territory except by virtue of a permissive rule, and this is quoting directly from the decision, derived from international custom or from a convention or absent the consent of the host state. So, the court's solicitous attitude in this area was likely influenced by its concerns to enhance international cooperation in an era of globalized crime, and as it was previously in extradition cases, which I discuss in the paper. And the court defends the argument by saying that any other interpretation of the Charter would be unworkable. And this is a sort of particular question I want to ask. If the Charter does in fact apply extraterritorially, as I want to suggest, what would the limits of the Charter actually be as a matter of international law? So, one possibility, and this is the view ultimately rejected by the court, is that one could impose a standard of ex post facto scrutiny on actions of Canadian officials taken overseas, or on the actions of foreign officials if you wish to give effect to the Charter for proceedings in Canada. Thus, for instance, a failure to provide a Miranda warning in the United States would render a confession by foreign officials, a confession given to foreign officials inadmissible in Canadian courts. But the court rejects this view. And it's this rejection that I find the most interesting. So the oddest feature of this case is that the court has consistently held that the principle of comity may give way where the participation of Canadian officers in investigative activities sanctioned by foreign law would place Canada in violations of its international obligations in respect of human rights. So in general, the court says, we won't give effect to Charter protections except where the actions of Canadian officials go so far as to violate an international human rights treaty. Now, there's no obvious principled reason to think why this should be so. And I want to suggest, in fact, that this goes against the practice of international courts and tribunals, broadly speaking. So, it is the case, generally, that constitutions and bills of rights don't apply extraterritorially. But it's not the case that the protections of constitutions and Bill of Rights do not apply within the country in domestic criminal proceedings, or in any proceedings, either civil or criminally more broadly. So, how would something like this work? Well, I want to suggest that, in fact, the minority opinion in HAPE is more compatible with the protection of the rights of Canadians in Canada. There's no principled reason, I would suggest, why Canadian courts cannot review the actions of foreign sovereigns for their compatibility with the Charter, provided that those actions, and then make a determination as whether or not any evidence seized or any confession so obtained is, broadly speaking, admissible in Canadian courts. Now, I think the court has confused two possible ways under which you might understand the term comity. You might understand the term comity to mean no scrutiny of the actions of foreign officials. And you might conversely understand comity to mean no scrutiny of the actions of foreign officials, but scrutiny of the effect to be given to the actions of foreign officials in Canadian courts. And I want to suggest that it's actually the latter that is not only part of international law, but most importantly, part of our constitutional tradition. So it is the case that Canadian courts consistently analyze the actions of foreign sovereigns. In any case in private international law, it has been traditionally the pattern of Canadian courts to analyze foreign marriage documents, wills, rules of inheritance for compatibility with Canadian public law. And there's a line of cases that says Canada will not give effect to the action of foreign sovereigns if they violate public policy in the private international law realm. So there's simply no reason to think, therefore, that Section 7 protections should be any different. It's entirely possible for Canadian courts to say, we will not scrutinize the actions of foreign sovereigns. The only question we will ask under a modified version of what would look to an American lawyer like the state action doctrine is the only question we will ask is whether or not we can give effect to these protections within the Canadian human rights. Sorry, whether or not we can give effect to these foreign actions within the Canadian judicial system. So in a case like Hape, the question would be not were charter rights exactly complied with in the search, but were there minimum protections afforded a Canadian national overseas? And were these protections, broadly speaking, compatible with the same protections afforded a Canadian? Or in a case like Cook, dealing with confessions overseas, the question would be, was the Miranda warning provided in the United States sufficiently similar to a similar warning that would have been issued in Canada to allow Canadian authorities to give effect to it in Canada? So I recognize I've gone through a really large amount of international law in about 17 minutes while people have been eating. So I think this is probably a good place to stop. And I think we're going to take questions collectively at the end. Is that correct, David?
I'm not sure.
Okay, then I'll make a ruling by fiat that we are going to take questions collectively at the end. So thank you very much.
So I am pretty much an ignoramus about international law, so I don't know how much sense the question is going to make, but isn't comity, the way you described it, isn't it something of a smokescreen when the courts, what they really want to say is institutional competence, and we don't trust ourselves. We don't know what the consequences of us doing this will be, and we were just afraid of actually doing something that's going to piss somebody off, to put it bluntly. It seems that that was probably what was going on, or at least a big part of what was going on in the Cotter case, for example. So I'm wondering what your thoughts are on it being the issue more broadly.
Well, no, thank you. So that's a really interesting question, right? I mean, there's always this question to the extent to which courts are just acting cynically in providing reasons. So I want to suggest that that may very well be part of it, but that doesn't actually explain the holding in Cotter, right? So you've got the twin Cotter cases, 2008. The court orders the government to make evidence available to Mr. Cotter as part of his defense, and then in 2010 does not, sorry, I may have that backwards, but then in the other decision does not require the government to demand Cotter's repatriation. So if you're thinking about like activities which are going to annoy other countries, presumably this criticism of Canadian participation in the interrogation at Guantanamo Bay has to be high on that list. Now, with respect to the specific question of just broadly speaking, are Canadian courts concerned about what the consequences of this might be? I don't know that that's consistent with their practice more generally, right? So the problem is Canadian courts do apply foreign law, and they apply this on a regular basis in the context of private international law adjudication, right? We see the use of foreign experts all the time. We also see the scrutiny of foreign judicial documents all the time, albeit in different sorts of cases. So it's not the case that courts don't analyze the actions of foreign sovereigns. It's just in this particular context, in the realm of extraterritoriality, the courts have been particularly reluctant to do so. And I would note there's a certain sort of way in which there's been a timidity here that's just not met in other jurisdictions. So European Court of Human Rights cases, and there's a little footnote in here because this is really just another paper I would have to write, but the European Court of Human Rights, applying the Convention, has traditionally held that the exercise of any power overseas would bring an individual inside the ambit of ECHR protections, right? So there is actually a broader, more principled approach available to the Canadian courts, grounded in, state practice in sort of similarly situated states, right? I mean, in some ways, the Canadian solution, like so many Canadian solutions, seems deeply dissatisfying because it's wedged between the American, we won't ever give extraterritorial protections, and the European, we will give a more robust set of extraterritorial protections. But thank you for the question. Okay. Go for it.
Yeah, sure. I'll stay seated if it's okay.
Yeah. Just make sure the mic is on. How did you make sure of that? Does it work? Yeah. All right.
Before beginning, I want to thank Professor Joanne Poiré, under whom I wrote this paper last summer. I also want to mention that I wrote this paper initially in French, so if my English is fuzzy, please excuse me. So my paper is titled In Search of the Matter-Informed Theory of Parliamentary Sovereignty in Canadian Law, originally titled À la recherche des limites procédurales à la souveraineté parlementaire en droit canadien. So it deals with a structural principle of the Canadian Constitution, which has been inherited from the British Constitution through the preamble of the Beanie Act. And so I draw some parallels between the doctrine in UK and the doctrine in Canada. And so in the UK, the study of parliamentary sovereignty is really, and the limits and the consequences of its deployment in British political institution is has been a long, really interesting subject for English constitutional experts, and much more so than in Canada. And so one of the most important and long-standing debate on the limits of sovereignty of the British Parliament is the one and the question of whether and how, if at all, it can bind itself in the future for the future by imposing on itself a more demanding legislative procedure than ordinarily employed. So recognizing that the legislature has such a capacity suggests that the validity of a law may be subject to the manner and form requirements by which it is enacted, and therefore that compliance with a special procedure is subject to review by the courts. This debate is of such importance to our understanding of the relationship between the different branches of the state that it has been the subject of both recent and long-standing speculation in many Commonwealth jurisdictions, such as Australia, New Zealand, and South Africa. Nevertheless, in Canada, the issue has rarely been debated, and few cases have considered it, no more than a few dozen in the last 3 decades, including inferior court judgments. And quite the contrary, here in Canada, the matter-informed theory of parliamentary sovereignty has largely been accepted in doctrinal work of Canadian constitutionalists. However, the Supreme Court of Canada has never ruled clearly and decisively on the issue. And the leading case on the matter-informed theory goes back to 1991, which is the Canada Assistance Plan Reference, the CAP reference, and it remains ambiguous in that regard. So that being said, 2 recent decisions of the Supreme Court of Canada, 2 decisions of 2018, the Mickey Sue case and the reference about pan-Canadian securities regulation, seems to suggest that the Parliament and legislature may bind themselves through matter-informed conditions in Canadian law. So underlying this, the matter-informed theory in Canadian law is the understanding that Parliament and legislatures may bind themselves through formally ordinary law for the adoption of future laws. A law enacted in violation of matter-informed conditions would be, in the eyes of a court, invalid, or more precisely, ab initio invalid, on the basis of not respecting a formal procedure. So in other words, the matter-informed theory would understand that the Parliament can make it more difficult for laws to be amended or repealed, or for certain types of legislation to be enacted in the future by changing a set of rules through legislation. And this raises the question of the legitimacy of courts to review legislation on the matters of procedure. And so my paper dissects first the matter-informed theory and what it entails in British law and how it's been understood, and basically what parliamentary sovereignty is as a doctrine in the British Constitution, but also how it's transferable and how it's applicable in Canadian law. And so my first chapter is more theoretical in nature and focuses on the underlying main rules that the doctrine of parliamentary sovereignty imposes on Parliament and the courts in the UK and in Canada, and how the matter-informed theory purports to change them. And so through this theoretical inquiry, we get a sense of the practical effects that such an understanding of parliamentary sovereignty allows, but also how it's difficult to transfer it in Canadian law. So my paper does not take for granted that practical upsides of a theory translates into theoretical plausibility. And so my second chapter inquires into the applicability of the theory in Canadian law by looking at case law and how it's been understood in Canadian law, and also how the constitutionalists such as Peter Hogg and Brun, Tremblay, and Bourriette have understood the doctrine, and how it, for me, there are some problems with that understanding. So without going through the arguments and the theoretical perspectives on the question, I'll go quickly summarizing my first chapter and the second chapter also. And so my first chapter, as I mentioned, is focusing on what's parliamentary sovereignty as a theoretical and constitutional doctrine in English law, and how it's been understood first by Dicey, of course, because one has always to go back to Dicey first to understand what parliamentary sovereignty is, and how it's been understood subsequently to make sense of the political changes in the UK. And so the orthodox understanding of parliamentary sovereignty is put forward by Dicey and Wade, most clearly and compellingly. And so it basically says that the Queen in Parliament is the source of the legal norm, and that's a legal fact, which is a rule that describes the relationship between Parliament and the courts. And so in the orthodox understanding of parliamentary sovereignty, there's a positive limb and a negative limb. The positive limb basically says that Parliament can enact any law and cannot bind itself. And so, as a result, there can be no entrenchment of laws because of the doctrine of implied repeal, which means basically that when an act of Parliament conflicts with an earlier one, the later act takes precedence. And as Wade says, the only limit on parliamentary sovereignty is that Parliament cannot limit its own sovereignty. And the negative limb basically says that there's a supremacy of enacted law on the executive and judicial branches of the state. And so judicial review of duly enacted law is not permitted. Only a basic form of judicial review can be applied to verify the authenticity of a law by looking at a parliamentary role. And so, as Lord Simon says in Picken, the courts in this country have no power to declare enacted law to be invalid. This includes immunity from procedure being reviewed. And so it's been commonly understood in British law that there can be no entrenchment of Bill of Rights or such things because of the orthodox understanding of parliamentary sovereignty. And also because there's, if you want to review laws, there must be a legal norm to which you can verify, or you can verify the validity by looking at a legal norm. But in British law, it's been commonly understood that there's no such legal norm to which you can refer to evaluate the validity of a law. So usually the courts will refrain from doing such an exercise. And I realize there's also some theories developed, such as the common law constitutionalism theory, but I won't go into that too extensively. And so my next step would be explaining a bit the matter-informed theory of parliamentary sovereignty, which is put forward by Jennings, Latham, and Euston, more importantly. And basically it says that the basic premise of the matter-informed theory is that since parliamentary sovereignty is legally illimited, it must also have the inherent capacity to modify the rules conditioning the valid enacting of law. In other words, to cite Jennings, its power to change the law includes the power to change the law affecting itself. And so it's based on the work of Latham, who basically first understood that there must be some principles or some rules guiding the courts or the courts to understand what is a valid law and what makes a law or a duly enacted law. And so he says, principles in the Constitution prescribing what form of the sovereign's acts will be recognized as valid, and where the purported sovereign is any but a single actual person, the designation of him must include the statement of rules for the assignment of his will. So basically the understanding that if Parliament says something, there must be a way to know that it's a valid legal norm as put forward by the Parliament. And so the matter informed theory posits that there is a fundamental difference between a limit through the legislative power over a certain matter, substance, and a limit to the way that legislative power can be exercised, form. So there's a difference between substance and form. And as Jeffrey Marshall says, basically, is that rules that simply define the procedures through which legal changes are effected are not fetters or limits on power and then do not constitute restrictions on sovereignty. So it's just the understanding that if you put a more difficult procedure to amend, repeal, or adopt new laws, then you're not restricting the sovereignty of the Parliament because it can still legislate over the substance, albeit more difficultly because of the form. And so this understanding was influenced by what is commonly referred as the Commonwealth cases. Basically 3 cases, which are Trethowan, Harris, and also Renessing in British Island. In all 3 cases, matter-informed conditions were used to invalidate law enacted in disregard of the procedural requirements. And so the courts, the understanding that flows from these cases is that the courts can review laws on procedure only, and parliamentary privilege does not apply when Parliament clearly expresses its will to be binded. And so laws can be entrenched or ordered to repeal or abrogate, and also coming from this understanding of parliamentary sovereignty is an influence in UK law, and as such in 2005 there's cases at the House of Lords called Jackson, where 2 of the 9 judges have strongly hinted that the matter-informed theory is applicable to the case to understand what's going on, but I won't go too far into the Jackson case because time is running. And so the Commonwealth cases have commonly be understood as something that does not fit with an orthodox understanding of parliamentary sovereignty. But such scholars as Wade have replied to the understanding that flows from the Commonwealth cases, arguing that it does not apply in UK law. And then there are also some other constitutionalists, such as Professor Carner and Professor Goldsworthy, who have argued that a parliament, to have the capacity to bind itself for the future enactment of legislation, there must be a supra-legislative basis. And so in the Commonwealth cases, such as Trethowan, for instance, the Colonial Laws Validity Act explicitly allowed for colonial legislatures to enact binding matter-informed conditions. And the legal source for the review and invalidation of the colonial laws is supra-legislative because it's from the imperial parliament. And likewise, in Canadian law, there are such scholars as Maxime Saint-Hilaire and Patrick Vaux, who have argued that since there are no legal basis in the Constitution to make matter-informed conditions binding in law, then they cannot be binding, because then there would be no legal basis in the Constitution, no legal norm for the basis of invalidation of laws. And so, and then I go through a bit the understanding of Canadian law and how it differs from the parliamentary sovereignty doctrine in Canadian law, and how it differs from a UK understanding of parliamentary sovereignty, and for many reasons, such as the basic fact that there's a constitution, a legal norm in Canada, so that it's not exactly a system of legislative supremacy, but more of a constitutional supremacy, and there's a basis for the review of laws, which has always been there, which is the division of powers. And since the very beginning of the Confederation, laws could be invalidated through the BNA Act. And so there's also the charter now, which limits the power of legislatures. But the question still remains whether the manner-informed theory is applicable, and there are such manner-informed conditions, as we can say, in the Constitution of Canada. For instance, Section 133 of the BNA Act is a manner-informed conditions in the sense that it purports to bind Quebec legislature to enact laws both in French and English. And so in the Constitution, there are such things as conditions for a valid enactment of law. But the question is Parliament able to impose on itself new conditions of manner and form through ordinary enacted law? And so, for some constitutionalists, as Peter Ogg, this is possible, but for some others, as I've already mentioned, this is not possible. And so the issue here, and then I go into my second chapter really quickly, go through it really quickly, but the second chapter basically inquires into what the arguments are for the applicability of the understanding of the manner-informed theory in Canadian law, by understanding what the argument is by those constitutionalists who have argued that it is applicable in Canadian law. And so the main argument for the manner-informed theory in Canadian law is basically a jurisprudential argument based on two older cases of the Supreme Court of Canada, namely Mercure and Dry Bones, the two cases. And so I inquire also into the Mikisu case and the reference about securities that were recently rendered by the Supreme Court, and dissect how they understand that in arbiter, of course, but how they understand that a manner-informed theory could apply. And so I question the basis for such reasons of judgment and for such an understanding of parliamentary sovereignty in Canadian law by rejecting the jurisprudential argument, which is the basis for those judgments. But I'll also inquire on the difficulty of the test for finding that there is such a thing as a manner-informed binding in law. And so without going too much in details, I would just say that there's an important distinction to be made between what is a constitutional norm and what is a legislative norm. And so in the reference about Canada's assistance plan, Judge Pig has a really good understanding of what that is. It basically says that there's such a thing as binding conditions in the Constitution, but it does not flow that legislatures and Parliament can freely modify those conditions. And so I see that the time is flowing, but basically what I say is that there are many problems also with the test, which is basically that is set forth in the reference on securities, which is basically that whenever there's a clear intention of the Parliament to be binded, it can be a binding requirement of a manner-informed condition. And so I inquire into how that was interpreted by the lower courts and show that it just has no sense of consistency because the test is so ambiguous and unclear. And so I show that in some situations it was applied, and at other times it wasn't applied. And so I show some understanding of difficulties and the conceptual and the practical difficulties of manner and form in Canada. And so if I see that, I have to open the ground for questions now. If anyone has questions. Jesse, I waited for you. I knew you were planning a question for me.
Yeah. So now I'm finding out that Professor Saint-Hilaire and I disagree on the procedural aspect of parliamentary sovereignty. But it's interesting what you're saying, because I think generally what's more controversial in the doctrine is to say that parliamentary sovereignty has a substantive component, right? That there might be procedural limits, but some scholars go further than that and say that there are more substantive limits. But it seems to me that what you're saying is that in the Canadian context, we have substantive limits, and that's fine, but procedural limits we can't have. So it's just interesting because I think generally the substantive, certainly in the UK doctrine on this, the substantive component is more controversial, I think. But it seems to me that what you're saying is that we can accept the more controversial proposition given the Constitution that we have and the Charter and the division of powers, but that the procedural component, the manner and form requirements, we can't have. I don't know if that's your position specifically or if you're just describing, but I'd just like to hear you on that.
Yeah, so I couldn't touch upon it too much because I saw the time was running, but from my understanding is that, as you said, there are some substantive limits on parliamentary sovereignty because of the Canadian Constitution, and I would argue that the same can be said about procedural limits because of the Constitution, because there are some manner and form requirements, such as, for instance, the Article Section 133 of the Constitution Act, but also there's other requirements, such as, for instance, the assent of the Gouverneur Général, and there are many requirements by the Constitution. And so the question, what was theorized by Latham, is that there must be rules in the Constitution that says what a valid law is. And so from my understanding, it does not flow from the fact that there are such things as rules that make us understand what a valid law is. It does not flow from that you can freely modify them, especially if there's such a thing as a constitutional supremacy, because then it would imply that a parliament could freely enact new procedural elements that would have for an effect of being able to render invalid duly enacted laws in the future. I don't know if that answers your question.
So it seems to me that manner and form requirements have to be considered as constitutional amendments, and I'm wondering if you think that they can be validly enacted under Section 44 or 45 of the Constitution Act 1982, or they fall under, I guess, Section 38. And if it's I guess I don't, yeah, as a sort of follow-up question, maybe especially if you think, as I'm inclined to actually, that maybe Section 44, 45 are sufficient authority for those, maybe, then is there a difference between the meaning of those provisions in 1982 and the meaning of those provisions today? If we go, so would there be a difference for an originalist interpretation and a living tree interpretation in light of developments, if any, in the scholarship and doctrine that may have occurred between 1982 and today?
Just to make sure that I understand the question, you're asking me if the scholarship would have influenced the understanding of parliamentary sovereignty.
So if we think, I'm kind of trying to think it out loud, but if we think that authority for providing for manner and form requirements, if it exists in Section 44 and Section 45, which, if I remember correctly, say something like Parliament can make laws in relation to the Constitution of Canada. Does that expression, making laws in relation to the Constitution, would its meaning have changed in regards to manner and form requirements between how it would have been understood in 1982? So, for example, might it have been understood as not allowing for manner and form requirements in 1982, but the view is different now, or maybe vice versa?
So I would say that is the case. And what I mean by that is that the courts have understood this as being as manner and form being possible, but I don't think that in 1982 there was such a thing as an authority in the Constitution to have binding matter-informed requirements. Because I'll just give I couldn't give the example in my discussion, but there's such a thing in Australia as a section which recreates the effects of the Colonial Laws Validity Act. And so the states in Australia may impose on themselves matter-informed conditions, but the Commonwealth Parliament may not, because of there's no legal basis in the Constitution. And so in my view, if we were to accept that in Canadian law we can adopt matter-informed conditions without a basis in the Constitution, that should be considered as an amendment to the Constitution.
Thanks.
Thank you very much. Is this the first year for these types of papers for Runnymede students?
Yes.
Congratulations, you're the first two winners then, so full marks to you. And full marks to Mark Mancini for developing this program and getting it going. I quite enjoyed the presentations. I have to admit that I was looking forward to the first one when I heard the opening remark and you talked about the role of comedy in the law, and I thought, oh, we're going to get the funniest Supreme Court judgment of the last 10 years. But I did come to understand the paper, and I want to thank you both and applaud you for your success in this and all continued success in the future. Go Runnymede.